Welcome, curious minds, to the deep dive. We're tackling a question that, at first glance, seems incredibly simple. Can you truly own a color?
Yeah, not just like in your logo.
Exactly. But the color of something is every day as, say, a medical glove.
Right.
You might think the answer is obvious, but trademark law, as we'll discover, dives into these questions with surprising depth, and the answers are, well, rarely straightforward.
It's definitely not a simple yes or no.
Today we're embarking on a deep dive into a truly fascinating legal battle that explored precisely this: the attempt to trademark a specific shade of dark green for medical examination gloves.
Mm-hmm. A very specific case.
Our focus is on the recent decision for the United States Court of Appeals for the Federal Circuit in APT Medisafe Technologies.
That was decided April 29, 2025, and there was a little update, an errata, on July 3rd.
Right. So our mission today is to unpack this case to show you how trademark law grapples with these non-traditional marks like color.
And what generic really means in this context.
Yes. And why this particular dark green glove ultimately couldn't secure its exclusive color registration.
It's a great way to understand how courts decide if something like a color is distinctive enough to be a brand.
You're going to get a shortcut to understanding those nuances.
It really is a perfect illustration, how something as basic as color can become this complex legal battleground in IP.
IP being intellectual property, of course.
Right. In this case, it just crystallizes that constant tension in trademark law,
Which is?
balancing a company's desire to stand out, to differentiate its products,
Okay.
with the public's right to use common or, descriptive features, things everyone should be able to use.
The tension is absolutely key.
Yeah.
So let's zero in on the company here. PT Medisafe Technologies, they make and distribute medical gloves.
Mm-hmm.
And they made a pretty bold move, applying to trademark a very specific color.
Which was?
The color dark green, Pantone 3285C, as applied to the entire surface of the goods, which consist of chloroprene examination gloves.
Wow, okay. Specifying the Pantone number really underscores how deliberate they were.
Absolutely. This wasn't just any green. It was their specific dark green.
They wanted to own that shade for those gloves.
Precisely. Their application included a drawing, a hand-shaped glove outline filled with that dark green.
And it showed the placement, right?
Yeah, a broken line showed the positioning, but wasn't part of the mark itself. And of course, they included a picture, a specimen image of an actual dark green glove.
To show how it looked in the real world on the market.
But right out of the gate, Medisafe hit a snag. A big one.
What happened?
The Patent and Trademark Office, the PTO, their examining attorney, found this dark green color was not inherently distinctive.
Okay, and that's a crucial finding. What does that mean practically?
Well, it meant Medisafe couldn't just register it straight away. They had to prove something called acquired distinctiveness.
Sometimes called secondary meaning.
Right. Essentially, they had to show that because they'd used it so much, the public had come to specifically associate that dark green color with Medisafe's brand.
Not just with chloroprene gloves generally.
Exactly. It had to point to them as the source.
And that's a much higher bar to clear, evidence-wise.
Oh, definitely. Proving acquired distinctiveness requires strong, compelling evidence that consumers actually make that mental link, color to source.
So what did Medisafe do? How did they try to prove it?
Well, first, they submitted declarations from their executive vice president and some promotional materials, brochures and things.
Standard first step, often.
But the examiner wasn't buying it. They then asked for more evidence, specifically color photographs and color advertisements showing competitive goods in its industry.
Ah, so they wanted to see what else was out there, what the competition looked like.
Exactly. And after reviewing that, the examiner reached a conclusion
Which was?
that the proposed dark green color mark was, in fact, generic.
Generic. Okay, that's even tougher than just lacking inherent distinctiveness.
Right. And crucially, the examiner also found it had not acquired distinctiveness either.
Double whammy.
Pretty much. So registration was refused on both the principal and the supplemental registers.
Wow. Okay, for listeners, maybe quickly explain the difference. Principal versus supplemental.
Sure. Think of the principal register as the main stage, giving you the strongest, most immediate trademark rights. Full protection.
Like the gold standard.
Yeah. The supplemental register is more like a waiting room. For marks that aren't distinctive yet, but might become distinctive later with more use?
So getting refused on both registers means the PTO saw very little chance for this color on its own to ever function as a unique brand identifier for Medisafe.
Exactly right. Which brings us to the core issue, genericness. Could you unpack what generic really means in trademark law? We use the word casually, but legally.
Sure. Legally, a generic term or mark is one that names the class or category of goods or services itself.
Like trying to trademark the word chair for chairs.
Precisely. Or medical glove for medical gloves. It's the common name for the thing. It can't distinguish one company's chair or glove from another's because it just identifies what it is.
So if it's generic, it just can't be a trademark.
Correct. It's considered incapable of indicating source. This whole idea was really cemented in a case called H. Marvin Gin Corp. v. International Assin of Fire Chiefs, Inc. back in 1986.
Okay, H. Marvin Gin. What was the test they established? How did they figure out if a word was generic?
It's a pretty logical two-step test. Step one, what is the genus of goods or services at issue? Basically, what's the product category we're talking about?
Right.
Step two, is the term understood by the relevant public primarily to refer to that whole category, that genus of goods or services, not just one specific brand within it?
Okay, that makes total sense for a word like glove. But we're talking about a color here, Pantone 3D285C. How do you apply a test designed for words to a visual thing like color? That seems different.
It absolutely is different, and that's where the law has had to adapt. It's a real challenge, you know? How do you figure out if a visual element like dark green has become so common that it just signals the kind of product, not a specific brand?
Yeah.
So, to tackle this, the Trademark Trial and Appeal Board, the TTA, or the board, they developed a slightly modified version of the H. Marvin Gin test, specifically for single color marks.
When was this?
This came out of a 2019 case, Milwaukee Electric Tool Corps v. Freud America, Inc.
Milwaukee Electric Tool. Okay, so a newer color-specific test. What are the steps for that one?
Well, step one is the same. Identify the genus of goods or services. What kind of product are we dealing with?
Okay.
But step two is adapted for color. It asks, is the color understood by the relevant public primarily as a category or type of trade dress for that genus of goods or services?
A category or a type of trade. What does that mean exactly?
The key question really is whether that color is so common within the relevant genus that consumers would primarily associate it with the genus rather than as indicating a unique source of goods within the genus.
So does the color just mean this type of glove, or does it mean this glove from Medisafe?
Precisely. Has the color become almost like a visual adjective describing the whole product category? Or does it function as a brand name?
That distinction feels absolutely critical. So how did the board apply this Milwaukee test to Medisafe's dark green gloves? Let's get into the specifics.
Right. First hurdle. Defining the genus of goods. What category are we actually talking about?
And Medisafe had their own idea about that.
They did. They tried to define it quite narrowly. They proposed the genus was chloroprene medical gloves sold only to authorized resellers.
Trying to limit it to their specific sales channel. Why would they do that?
Well, presumably, if the category is smaller and more specific to their business model, it might be easier to argue their color is distinctive within that narrow category. Fewer competitors to compare against, perhaps.
Makes sense strategically. Did the board accept that narrow definition?
No, they rejected it. The board defined the genus more broadly, simply as chloroprene medical examination gloves. Full stop.
And why did they reject Medisafe's definition?
Because the board isn't forced to accept an applicant's preferred, often self-serving, narrow definition, especially, as you can imagine, if it seems designed to artificially limit the comparison pool mainly to the applicant's own stuff. That wouldn't give a true picture of the marketplace.
Okay, that's a really important point. It's like trying to trademark, I don't know, the color red for sports cars sold only on Tuesdays.
Exactly, it wouldn't fly. So genus defined broadly. Chloroprene medical examination gloves. Then came step two. Public perception of the color itself.
And what did the board find there?
They found Medisafe's dark green color mark was generic.
Generic. So not just lacking distinctiveness, but actually generic for that category.
Correct. Their reasoning was that the color is so common in the chloroprene medical examination glove industry that it cannot identify a single source.
Okay, so they're saying lots of people use this color or something very close to it. What was the proof? What evidence did they rely on?
The board leaned heavily on evidence the examiner had found, primarily screenshots from third-party websites,
Showing what?
showing other companies selling chloroprene medical examination gloves in the same or nearly the same dark green color.
So direct evidence of competitors using that color.
Yes, they looked at about 25 examples. Now, Medisafe actually claimed they were the manufacturer for 15 of those examples found online.
Okay, so maybe those were just their gloves being resold.
Some were, but here's the crucial part. The other 10 examples were from unaffiliated sellers, other companies entirely.
So clear evidence of third parties, competitors, using a very similar dark green for the same type of glove.
Exactly. That widespread third-party use was really the nail in the coffin for the genericness finding. It showed dark green wasn't unique to Medisafe in that market. It was already a common feature.
Right. And here's where it gets, I think, really instructive for anyone trying to register a non-traditional mark. Medisafe tried to fight back, right? They presented rebuttal evidence.
They did. They tried to counter the finding of genericness and also bolster their claim of acquired distinctiveness.
But it seems like their evidence just didn't hold up.
It really didn't, and this part of the decision is almost a masterclass in what not to do when trying to prove your case. It's a cautionary tale.
So what did they try first?
First, they pointed out that other manufacturers made gloves in other colors too, blue, black, etc.
Their argument being, see, it's not only green.
Pretty much. But the board gave that argument little weight. Why? Because showing other colors exist doesn't prove that dark green isn't generic for this specific type of glove.
Right, it doesn't negate the evidence that dark green is commonly used. Okay, what else? Did they use customer declarations?
They did submit some declarations from customers. Those are often used to show that people associate the mark with the source. But the board found them not sufficiently representative or convincing.
Why not? What was wrong with them?
A few things. There weren't very many of them. They were all identical in form, like they just filled in a template.
Not very organic sounding.
Exactly. And they were pretty conclusory, just sort of stating the conclusion without much detail or explanation. That really weakens their persuasive power. They don't feel like genuine, spontaneous expressions of how customers actually think.
Okay, so weak declarations. What about a survey? Surveys are often seen as strong evidence in trademark cases.
They can be, if done properly, but Medisafe's survey, well, it backfired spectacularly.
How so?
The board found the survey was so flawed as to be entitled to no probative weight. Basically, useless.
What were the flaws? This sounds juicy.
Several major issues. First, it was administered by Medisafe's own lawyer, not an independent survey expert. That raises immediate bias concern.
Yeah, flag number one.
Big time. Second, it was only sent to 6 established customers. That's a tiny sample size, and likely biased towards people already familiar with and potentially favorable to Medisafe.
Not representative of the broader market at all.
Not even close. Third, the board found it used leading questions, meaning the questions themselves might have suggested the desired answer.
Okay, so flawed methodology, tiny biased sample, leading questions. Anything else?
Yes, and here's the real kicker. Even with all those problems, designed arguably to get a favorable result, only 3 customers actually responded. And one of those 3 respondents still said Medisafe's color mark was not distinctive.
Wow. Even with a stacked deck, they still got a negative response.
Exactly. It completely undermined their argument. If even one of your hand-picked established customers asks leading questions by your own lawyer, says the color isn't distinctive, how can you possibly argue it has acquired distinctiveness in the wider market?
That's bad. That's bad. So their evidence just crumbled under scrutiny.
Pretty much. It serves as a really strong warning. You need rigorous, independent, representative evidence to prove acquired distinctiveness. Shortcuts or self-serving data just won't fly.
Okay, so the board says generic, refuses registration. Medisafe, understandably, appeals this decision. Where do they appeal?
They appealed to the U.S. Court of Appeals for the Federal Circuit. That's the court that typically handles appeals from the PTO's Trademark Trial and Appeal Board.
And what was the standard of review there? How does the Federal Circuit look at the board's decision?
The Federal Circuit reviews the board's legal conclusions de novo, which means they take a fresh look, no deference given to the board's legal interpretation.
Okay.
But they review the board's factual findings, like the finding of genericness, based on the evidence under a more differential standard, substantial evidence,
Indeed.
meaning they just check if there was enough relevant evidence that a reasonable person might accept as adequate to support the board's conclusion. They don't reweigh the evidence themselves, just see if the board's finding had reasonable support.
Got it. So what did the Federal Circuit decide? Did they agree with the board?
They did. They affirmed the board's decision. But more importantly, they did something significant legally.
What was that?
The court expressly adopted the Milwaukee test, that two-step test specifically for assessing genericness of color marks.
Ah, so they didn't just use it implicitly, they formally endorsed it.
Exactly. They stated it was appropriate and entirely consistent with the older H. Margan-Ginn test for word marks. This is a big deal because it officially makes the Milwaukee test the law within the Federal Circuit for judging color mark genericness.
That provides a lot more clarity for future cases, I imagine. Sets a clear precedent.
Absolutely. It solidifies the framework for how these cases will be
Right.
analyzed moving forward, a clear roadmap.
Now, Medisafe had another argument on appeal, didn't they? Something about the specific wording in the trademark statute.
Yes, they tried a linguistic argument. They pointed to the part of the trademark law about canceling registrations, 15 U.S.C. Section 5164. That section talks about canceling a mark if it becomes the generic name for the goods or services. Medisafe argued, well, a color isn't a name, so maybe this cancellation ground, and by extension the concept of genericness, only applies to word marks.
That's a clever reading. Trying to carve out an exception for non-word marks like color, based on the word name.
It is clever, but the Federal Circuit didn't buy it.
What was their reasoning?
They flatly rejected that narrow interpretation. They essentially said, look, generic isn't just about words. A visual element, like color, can absolutely become so common for a type of product that it functions as the generic descriptor. It becomes the visual equivalent of a generic name.
So the function is the same, even if it's visual, not verbal.
Precisely. The court pointed back to one of its own earlier decisions, a 1999 case called Sunrise Jewelry Manufacturing Corp. v. Fred S.A. That case involved a metallic nautical rope design for jewelry. And in that case, the court had already established that trade dress, which is the overall look and feel, including things like color, shape, design, that cannot serve as an indicator of source, is generic and unprotectable.
So they were just applying that established principle.
Yeah.
If any aspect of trade dress becomes generic, it can't be protected.
Right. They explained that accepting Medisafe's argument would mean giving trade dress more protection against becoming generic than word marks get.
Which would be weird.
Exactly. It would contravene the whole purpose of the Lanham Act, which is our main federal trademark statute. The goal is fair competition and preventing consumer confusion, not letting companies monopolize common visual features of products.
So that generic name argument was shot down definitively. A visual can function as a generic identifier.
Correct. So the bottom line from the Federal Circuit was clear.
Which was?
They affirmed the board's determination. Medisafe's proposed dark green mark was generic for chloroprene medical examination gloves.
And therefore.
Therefore, ineligible for registration on either the principal or the supplemental register. End of the road for that trademark application.
And they also touched on the acquired distinctiveness point again, right?
Yes, briefly. They noted that because the mark was found to be generic, which they called the ultimate indescriptiveness, it inherently cannot acquire distinctiveness.
So once something is generic, it doesn't matter how much you use it or advertise it.
Yeah.
You can't make it non-generic again.
That's the rule. Generic is generic. It belongs to the public domain for describing that type of product. So the court said they didn't even really need to dig into Medisafe's arguments about the evidence for acquired distinctiveness because the generic finding made that whole issue moot.
Got it. Genericness is a fundamental barrier. Now, you mentioned an errata issued in July 2025. Was that important? Did it change the outcome?
No, not the outcome. It was more like a technical correction, cleaning up the language slightly.
What did it change?
Just a couple of small things. On page 2, they struck the phrase "or supplemental" from one sentence, likely just a minor wording clarification. And on page 7, they clarified language about the board's role.
How so?
It just specified that the board reviews the examining attorney's refusal based on the whole record, looking for substantial evidence of genericness. It emphasized the board is acting as a reviewing body, making its own findings, not like a prosecutor having to prove genericness itself.
So procedural clarifications, not changing the substance of the ruling that the color was generic.
Exactly. It didn't change the core holding at all.
Okay. So let's wrap this up. What does this whole case, this deep dive, really mean for you, our listener, and maybe for businesses thinking about branding?
Well, it vividly shows just how complex trademark law gets, especially with these non-traditional marks like color.
It's definitely not simple.
And the big takeaway is you can't just claim a common color for a common product, especially if that color is already widely used by competitors in that industry. The law steps in.
Why? What's the purpose of that limitation?
The law ensures that no single company can monopolize a basic descriptor, whether it's a word or a color, that consumers have come to associate with an entire category of goods, not just one brand.
It keeps things fair.
Exactly. It prevents unfair competition. It ensures that basic, functional, or generic features, words, shapes, colors stay in the public domain for everyone to use. It promotes competition and innovation rather than letting one company lock up a common element.
So this decision helps clarify those boundaries,
Oh.
especially for color, by formally adopting that Milwaukee test. It gives companies a clearer roadmap.
It does. It reinforces that strong evidence of distinctiveness is needed, and widespread third-party use of a similar color is powerful evidence against distinctiveness, potentially showing genericness.
Right. Now, for a final provocative thought to leave everyone mulling over,
Okay.
think about the products you use every single day. Are there colors that immediately make you think of the type of product itself, rather than a specific brand?
Mm-hmm. Good question.
Like, is there a certain shade of yellow that just is school bus yellow in your mind? Or a specific red that universally screams fire truck?
Or maybe a specific blue for police cars in some places.
Exactly. Now, imagine if companies could actually get exclusive trademark rights for those colors, for those specific things. How would our world change? Visually, commercially.
Wow. Yeah, that would be restrictive. It would probably make things visually quite different, maybe less intuitive. And it could stifle competition if newcomers couldn't use the colors people expect for certain products.
It really makes you appreciate the balance the law tries to strike, even if it leads to complex cases like Medisafe's.
Definitely. It's a constant balancing act.
Well, we hope you've enjoyed this deep dive into the fascinating and surprisingly colorful world of trademark law and the battle over dark green gloves.
It was a great case to unpack.
Until next time, keep digging, keep learning, and keep asking those deep questions.